everyone. Welcome to what I can only describe as my most favorite episode of LA Legal. I'm Leanna. I am joined by Nima, and we are sitting on the same couch for once. But I have not been demoted. And so please introduce our very special guest from today.
I'm so excited to have one of my favorite people on the podcast. I have the good fortune of being on with him every week on Court TV. We have a think tank together. But today he's on the podcast LA Legal with me and Liana, none other than the famous Kirk Nurmi. He's joining us from Arizona. We're here in LA. Kirk, please introduce yourself. I'm so happy to have you on the show.
Nima, it's great to see you again outside the confines of Court TV. We can have a different sort of discussion. And Leanna, it's really nice to meet you, and I look forward to talking to you as well. I know you're excited to talk about this case. So, it looks like you came prepared with a list of questions and everything. So I am ready to go.
Got like 10 pages. I really do.
Yeah, this is like...
Okay,
this is
10
like
pages.
this is like bar exam level outline.
Oh, yeah, this is like law school outline.
Yeah.
I think, hopefully, Kirk, you booked 2 to 3 hours to talk about this case because...
I don't even want to talk. I just want to hear
I was going
you
to say,
talk.
I don't know if I can handle all these questions.
Okay, well, let's get started. I'll give our viewers a very quick intro. In June of 2008, Travis Alexander, Jodi Arias' on and off again boyfriend, was found in the bathroom of his Mesa home. He was shot in the head, stabbed 27 times, and his throat was slit, almost decapitating him. It was a gripping 21st century true crime drama that captured the imagination of followers and gawkers around the nation. So what about this case was so enticing to gain national attention? Its graphic descriptions of sex and violence, the behavior of the prosecutor at court and outside of it, and at the heart of it, a young, beautiful female on trial for the gruesome murder of her ex-boyfriend.
Well, Kirk defended Jodi Arias. So let's just... obviously we love him, but who better than to talk about this case? We have Jodi's number one fan here and Kirk's former client, who he defended for many, many, many days, which is why the outline is so long.
Yes. I mean, she was on the stand for 18 days.
Yeah, I think it's a modern day record.
I have questions for both of you. But Kirk, my first question is, and I think our viewers would want to know, how did you even get entangled in this case? How, you tell us the journey, how this was presented to you and your thought process when you heard some of the evidence. I'm sure you saw some of the footage of her interrogation with law enforcement. So talk to us about that sort of initial stages.
Before Kirk answers, I want to just say we should use the word trapped because that is the title of Kirk's series of books talking about this case. So how did Kirk get trapped with Jodi Arias? That's the word we got to use here.
Okay.
Trapped with Miss Arias.
Yes.
Trapped with Miss Arias is the book title, and you're gonna, as the podcast unfolds, you will see exactly why. But to begin with your question, I graduated law school in 2000. And about that time, Phoenix was a booming market. My wife and I got jobs down here. As you know, sometimes you can't get hired until you pass the bar. But I got hired as a law clerk in the Maricopa County Public Defender's Office, which is at the time, or it has been, about the 5th or 6th largest court system in the nation. And so when I passed the bar, I, had my briefcase and my little county ID badge, and I was a lawyer. And I had gone to law school with the idea I wanted to be a public defender under the belief that those who are accused of a crime deserve zealous representation, rather they can afford Nima Rahmani or, a public defender. So, I went about my career, did a lot of serious cases, but then at the time, we had a Harvard graduate by the name of Andrew Thomas, who was our county attorney, who had written some papers at Harvard advocating the advance of public stoning, what have you.
Oh, wow.
And you would be surprised that a guy like that was very pro-death penalty. So when he got elected, the death penalty was charged rather routinely. And I was at a point in my career where I was thinking about making some changes in my life. Trial after trial, case after case, the fables of a public defender are well documented. And so instead of going in private practice, I made the decision to go in the death penalty unit of the public defender's office.
Well, listen, there's one thing I don't like. Sorry, Kirk. There's one thing I don't like. There's those Harvard prosecutors, man. There's nothing worse than
They're
those
just the
people.
worst.
The
But
absolute
but do
worst.
you our
Well,
viewers
I've
like
never heard you
Harvard? There it is.
advocate public stoning, Nima.
Never, never.
7 minutes into filming, we get Harvard name drop. Just
Yeah.
putting that out there. So he lasted a whole 7 minutes without mentioning Harvard. But go ahead.
Well, yeah. In his defense, I brought it up today because I thought it was quite ironic that Andrew Thomas was a fellow alum. But to continue with the story, I was in the death penalty unit, and that requires two lawyers. You have to have a certain amount of experience in terms of trying major felony cases, as well as very specific training, because the work is quite rigorous. Obviously, it's the highest standard. It's going to be reviewed by the U.S. Supreme Court, what have you. So I started out there in 2008. Had my first trial under my belt. I tell the story in my book about being a second chair and having a death penalty verdict rendered into a courtroom, and seeing that the pain that caused, the lack of joy, but the utter pain that caused everyone involved, even the victims' families. And so, I made a vow to myself on a personal level that whatever case I had moving forward, I'd do everything I could to ensure that didn't happen. Now that I had gone through a trial, what have you. And as fate would have it, after that trial was over, you handle about two or three cases on a caseload. When that trial was over, my team, if you will, was up. It was next man up in terms of the cases that came. And by that time, Miss Arias had been in the system about a year, but had been her prior counsel from another indigent defense office had been allowed to withdraw. And I was assigned the case in 2008, knowing nothing about Miss Arias, certainly knowing nothing about what the future would hold for me in that case, or else, as I often say, I would have grabbed my briefcase and run out the door.
Little did you know, in 2023, you'd be sitting here talking to us about it, right?
That's right. And little did I know that, she wouldn't be sentenced till approximately 5.5 years after I was assigned to the case.
Well, I have to ask. I mean, obviously, public defenders, they are such an important part of our criminal justice system. Everyone is entitled to a legal defense. I'm going to be honest. I have clients that, sometimes I don't want to represent because I don't believe in their case. I don't personally like them, and I don't want to spend years litigating with them. Kind of going back, obviously we know that there were some efforts to withdraw from the case. Prior counsel withdrew. Do you think that there would have been a possibility on the front end of the case not to accept representation?
Well, not really. I mean, in the public defender's office, you have to have a darn good reason not to accept cases. And obviously, in the death penalty unit, all the cases are not good, right? And when I received the case, the name Jodi Arias was foreign to me, as it probably was to most people back then, right? 2008, she'd been arrested. There was one 48 hours documentary on the case, but knew nothing about her, right? So there was no reason for me. And of course, certainly, when you're in the death penalty unit, not liking a client or not liking what they did or not believing in their case isn't a reason to reject the case. Because if you think about it, Nima, under that standard, nobody would get a defense, right? I mean, a lot of defendants will say, my attorney doesn't believe in me. Well, you're not entitled to that under the Sixth Amendment, right? I mean, I've had clients that are on tape committing robberies, what have you, and say, well, my lawyer doesn't believe in me, so I want a different one. And every single time the judge says, no, you're not entitled to that, right? So ultimately, you're ultimately assigned by the court, right? And without a valid ethical reason to reject representation. And there was none. It was an empty file with nothing in it.
Got it.
Just a name.
So there was no breakdown in the sort of attorney-client communication, at least from the beginning, and the case hadn't really received all the press it did. That's sort of
Well, when I was assigned the case, I hadn't met her. When I was assigned the case, I had not met her. I was handed an empty file, and there was nothing. It was still the records needed to be transferred from the other indigent defense office. So really, it was ultimately my introduction to Miss Arias was just a name.
Got it.
Wow. Well, I was gonna say, I would imagine that most people on capital cases, right? It's not like they're good people. That most of them have done bad things, So it's like
No, of
it's the
course.
nature of the business,
No,
right?
and the only reason I'm asking, like that's what I was saying. Criminal defense lawyers, they have to defend people
Mm-hmm.
accused of crimes. No question. I'm just trying. At some point, the relationship breaks down. So I'm just sort of asking, where in sort of the timeline of the case does that
Yeah.
happen? So obviously, in the beginning,
Yeah. Well, let me address that, Nima. So in 2008, when I was assigned the case, I had obviously another case. We went to trial on a second capital case, which might not sound like a lot to a lot of people, but there were people in that unit that had gone 20 years without going to trial. And here I was going on my second trial, even a short trial. This was a cold case. It was sad. There was no family there, no nothing. It was empty courtroom. And even that lasted 3, almost 4 months. And of course, the lead up time with the experts and what have you is also quite extensive. And by that point in time, that was probably late 2010. It's been so long now, but I was really thinking about the future of my career. I realized that I didn't want to keep doing capital defense work because it was so draining. It did keep me so busy for so many hours. But I was cautious. My grandparents grew up in the Depression. They raised me. I was cautious to quit a job with a steady paycheck and healthcare and all those things. So, I really thought about it. And then come 2011, Miss Arias had a big hearing, but I decided to resign from the public defender's office with the idea that I would leave the case behind and I was going to go into private practice with someone who I'd gone to law school with. And that is when the judge took an uncustomary step and wanted a motion to withdraw in order that I keep the case. And ultimately, there was a series of litigation between the public defender's office, the Office of Court Appointed Counsel, myself, Miss Arias was appointed attorneys. And ultimately, at the end of it, at Miss Arias's urging to the court, and obviously through her lawyers, I was ordered to keep the case because she wanted to keep me on the case. And that's why I really say trapped with Miss Arias, because it wasn't a matter of being assigned a case that I ultimately didn't want. It was that I wanted to move on from the practice of capital defense work and go into private practice. And ultimately, that was hijacked in early 2011.
So let's talk a little bit about when you started getting a little bit more information on the file, right? And I'm talking about those interrogation videos because I think that's really what kind of put her on the map as this like potentially crazy, like the girls doing handstands. Have you seen them?
I've not seen.
So the initial interview with law enforcement, they bring her in. She's kind of like, doing her makeup, fixing herself up, not asking, like, why am I here, right? Because she sort of maintained that she has nothing to do with this. At no point in time is she like, why are you guys questioning me, right? She's like, helping them out. She's volunteering
Well,
her
in the
DNA.
beginning, she said she wasn't even there, right?
Right. She says so. Her story changes 3 times. But, the officer catches on to the fact that she's lying, steps outside. And so obviously there's footage of that, right? So she does a handstand, very normal behavior. And then she starts singing Oh Holy Night. Weird. Like reciting scripture. And so when I was watching it, mind you, I've watched this multiple times, I'm like, what is going on here? Right. And so when you see something like that, right, when that kind of gets thrown in your lap, what are your thoughts? Like, okay, now I'm dealing with someone who is maybe faking insanity, right? Because she's relatively smart, or she comes off as someone who's, somewhat bright. Does that to you kind of signify, okay, maybe she's like trying to fake insanity? Is she insane? Or what is happening here? Like, what are your thoughts when you hear something like this and you hear this story that doesn't really make sense, but, it kind of changes over time because then it becomes the
Well,
intruder story.
yeah, then it becomes the burglary
Yeah,
story, and then that she was attacked, and
right.
Travis was killed. I mean, I think it's hard. Obviously, as an attorney, you have your client on a recording,
Mm-hmm.
giving a statement, and you basically have to either craft your defense around that statement, or
Mm-hmm.
you have to go and pivot and go in a very different
Right.
direction, which is obviously
Right.
not easy because it subjects them to some pretty vigorous cross-examination.
I mean, I feel like this is good stuff for prosecution, right? But as a defense attorney, what are your thoughts when you're seeing this, when you're reading her file, getting to know her a little bit better? Like, what was that thought process like?
Well, I can't get into the specifics of my thought process. That's privileged a little bit. But what I would say in general is that, you know, not guilty by reason of insanity is a very tough burden in Arizona. And really, probably anyone that has functioned as an adult, paid bills, paid rent, made car payments, what have you, is not the sort that is going to be a viable for an insanity claim, right? And so, Nima's right. We all know, and obviously, we can only advise, you can't control. But she did the interviews in 2008. She was giving interviews in California before she was even extradited to Arizona. She was giving stories up in the Wairika jail. She was transferred to Maricopa County, where she had competent death penalty qualified an attorney. I saw it on the 48-hour special that I could tell that obviously she disregarded that attorney's advice. It wasn't me back then, and gone forward and gone ahead with the interview and told what she had about the various different stories about her relationship with Mr. Alexander, as well as what the intruder story, which later became to be known as the ninja story. She talks about people coming in and all the things that they did. So yeah, I mean, all of those inconsistent statements, along with a Inside Edition interview where she looks in the camera, says no jury will convict me, is obviously problematic, but those are the cards you're dealt, as it were. Those are the cards I was dealt, because all that was booked in by 2009 when I was assigned the case.
Yeah, and we talk about it a lot on court TV. I mean, but it must be so challenging. And we can just talk generally, right? Where you have a client you're trying to represent, and he or she is giving statements that will absolutely be used against them. This is just, criminal law and procedure 101. And obviously, Jodi Arias, I mean, there's so many different statements and so many different interviews, but we have cases that are going on right now. I mean, Donald Trump is out there, he's being prosecuted and he's giving statements,
Mm-hmm.
about him knowing that he has classified documents. That can't be helpful. Or even Alec Baldwin. I mean, it just recently got announced that the district attorney is going to try to indict him, at least apparently, based on, in large part, an interview he gave to ABC and George Stephanopoulos. And these are like very sophisticated people with
PR
great lawyers,
teams.
with PR teams, great lawyers like
Mm-hmm.
Kirk. It must be very frustrating, I would say, when you have a client that really won't follow your
Mm-hmm.
advice.
Right, right. So let me ask you guys both, right? Because this is really cool. Prosecutor, defense attorney, right? When you have multiple different stories, right? Conflicting stories. And so, first it's I wasn't there, and then it becomes, there's intruders and whatnot. They came in, they told me, we're going to kill your family, don't say a word, whatever, you run off. As a prosecutor, do you follow this train of thought? Do you say, hey, maybe this is true, let me look into this as law enforcement from your experience? Or are you thinking, all right, this is just a bunch of bogus and we're not really going to pursue this and entertain it too much? What kind of goes on behind the scenes with prosecution, law enforcement, when there's different stories?
Yeah, I mean, I'll give the prosecution perspective. And, from our perspective, we don't know what the defense is until opening. And sometimes they reserve opening, and we don't know until we even rest after a case in chief. So there are some instances where we might get wind. Some states require, for instance, notice of an alibi defense, or there's some affirmative defenses that where you have to provide notice. But if you're dealing with something like self-defense, for instance, that's usually not something that the defense needs to disclose to the prosecution, at least not in advance. And we're sort of prepared for anything and everything, because it could be it wasn't me, I didn't mean it, I
Mm-hmm.
was you attack identity, you attack knowledge and intent, you raise some sort of defense argument, affirmative defense, but you got to be prepared for everything as a prosecutor.
Yeah. I'm kind of I'm laughing on the inside because Nima's talking about this immense burden that the prosecutor has when he has all the power in his hand, and he's talking about how difficult prosecution is. But you know, in Arizona, self-defense, which Leah, I'm sure you know, is ultimately where she landed, is something that has to be pled affirmatively in advance of trial. But to back up a little bit in terms of, the what a defense attorney must do in a capital case is basically reinvestigate the case as if it's a cold case or what have you. Double check what the police did. I have investigators, I have experts. So basically, in that sense, the lead defense attorney is also the head investigator in terms of looking at the crime scene, seeing what was missed, seeing if there's anything that supports or detracts from the client's story, and then have those discussions and investigate everything that surrounds not only what the police found, but what the client tells you in once you've accepted representation or you're trapped, as I was.
Let me ask this, just from someone that defends capital cases. So obviously you have your guilt phase and you have your penalty phase, and I mean, we all know, we've talked about it at length. You have your death penalty qualified jury. They're more likely to convict, right? You have all this media attention. That makes it even more likely that you're going to end up with a guilty verdict. How much of the effort is focused on, the mitigation part of the case? Because, I mean, what we saw, and again, obviously a very different case, but we saw, with Nicholas Cruz, right? Worst school shooting in U.S. history. And the question I have is, for death penalty cases, if you're doing capital defense, is it an outright win if you save the defendant's life? Because, we're seeing a little bit of a strategy sometimes where more effort is sort of focused on the mitigation part of the case. You don't want to necessarily use your credibility on the guilt phase and potentially turn off some of those jurors. So we see a little bit more of the shift to the penalty phase.
Yes, ethically speaking, everyone who's versed in capital defense work will tell you job number one is to save the client's life. Because ultimately, when you have a prosecution where they're seeking the death penalty, guilt is pretty much presumed. You see a lot of these cases where the death penalty is sought out. Guilt is almost a given, for lack of a better way of saying it. So you're gearing towards the mitigation case, but you're also doing it in a way, Nima, in theory, that and it ultimately didn't happen in the Arias case for various reasons, but you are going to try to marry your defense to your mitigation. So, as you mentioned, so you're not losing credibility. It's one constant flow of a story that ultimately culminates in a life verdict, if you will. So, in that regard, that's what I say. Myself and my team won twice in this regard.
Yeah, that's absolutely true. And the self-defense argument absolutely is consistent with the mitigation. So
I agree. So let me ask you guys this really quickly. So, we have someone who's now giving like press conferences in jail and, clearly against the advice of her attorneys. How does that work? Is she like, as, someone who's incarcerated, about to go on trial, how does that work? Like, media contacts the defendant and they say, hey, we want to give an interview, and they just, how does that work? Because I saw a lot of I postings and stuff online. People were asking, how are they getting access to her without her attorney, mind you?
Well, I mean, so obviously we have a lot of clients. We do a lot of press for our civil plaintiff clients, and they get contacted by the press and media all the time. There's no restriction. Obviously, an attorney can't contact a represented party, so the prosecution would never do that, or let's say an attorney for one of the victims' families. But if you're a reporter, you're not bound by any of those same restrictions, at least here in California.
So they just reach out to folks in prison and.
Absolutely, if this person's willing to get on a phone call, they get on a phone call.
Yeah, I mean, ultimately, it depends on the policy of the facility. So the Maricopa County jails always allowed inmates to give a statement. The former sheriff very much enjoyed watching defendants stick their foot in their mouths and ruin their cases. So he was famous for allowing defendants to hold press conferences, what have you. And Leanna, if you go back, if you've ever seen that 48 hours interview that Miss Arias does with Maureen Maurer, you can see that the jail was so accommodating that they cleared the entire visitation area so Miss Arias could sit across from Miss Maurer unobstructed or undisturbed by anything around them, so she could get that interview. And of course, after her conviction, she famously gave a several interviews, one attacking me, putting my safety in jeopardy, that my safety and that of my family in jeopardy, as well as press conferences with Good Morning America and what have you, the next day after she had been convicted of first degree murder, and while we were trying to work on the mitigation case.
So let's talk a little bit about trial. This is where you just look at that smile. This is what Nima thrives on. So, prosecution comes on, and they're talking the motive, right? We need a motive. It's revenge. He breaks up with her. He's about to go to Cancun with another female who's a friend. We're not sure. I think they dated before. Seems like they had a platonic relationship. They're about to go to Cancun. And so prosecution, I don't know if you've seen the opening statement, but it's very passionate. It's very detailed. I want to know what your thoughts were, and then I want to know what your initial thoughts were. If you can talk a little bit about when you were listening, because it's like a 40-minute opening statement, and it goes into every sort of little gruesome detail. And because they go first, it's already painting a pretty convincing and very elaborate picture for the jury.
Yeah, well, no question, obviously. I mean, I agree with Kirk. Prosecution usually has the advantage, even though they have the burden. Procedurally, they go first, they go last. And, they sit closer to the jurors. I mean, there's many little things that end up being very big that give the prosecution the edge. And I think going first and kind of framing the case is one of them. And, I mean, we all know that as lawyers, motive isn't an element, doesn't have to be proven. But, here's someone that isn't a career criminal. She has no criminal history, really. And so jurors are going to ask why. Why would someone do this? Stab someone, 27 times, then shoot them. So I think it's very important for the prosecution to always tell the story. You don't want to get up there and say, well, yeah, we don't have to prove motive. That's not an element. I don't think, even though that might be the jury instruction, that's not something anyone wants to hear.
Well, yeah, to answer your question, I remember not being very impressed with the state's opening statement. It didn't seem it to me. It lacked a lot of passion. It was very factual, and it didn't really. I think there wasn't a lot of clarity on the issue of motive because, as you followed the case, what makes someone, she's in Northern California. She's miles away, right? And there's this theory that there's this trip to Cancun coming up and he's going with another woman. Okay, right. But does that really motivate someone to steal a gun from her grandparents' house, drive, and if you're on a covert mission, do you rent a car? That was always a question that I had, right? Is that doesn't make much sense because you give your driver's license, you rent a car, there's a tracking of it. You see people along the way, the cell phone goes dark somewhere in California heading east towards Arizona. Okay. But also then an explanation when we're purely talking about motive is if you're on a covert mission, not you, but in general, if you're on a covert mission to commit murder, do you hang out with someone and at their home for 12 hours, have sex with them, and allow them to take pictures of you, nude pictures of you at the crime scene? Wouldn't you go in there with this gun in hand? These are some of the questions I had going into the case back. It's not necessarily my thinking now, but going back into the case at trial, she comes in, it's verified she comes in at 4 a.m. She doesn't shoot him, leave, get back on the road. Because remember, she is due to be meet some friends in Utah later. She could say, hey, I took a nap. I decided to spend the night somewhere. Here I am. But she spends approximately 12 hours at his home. Now, to me, the state never offered explanation in terms of tying the motive to those 12 hours.
Yeah, and I think this is important, kind of just taking a step back, because obviously this is the premeditation, right? This is the first
Yeah.
degree. This is the basis for the death penalty, right? So, I mean, I think it's a very good defense argument, and it's certainly consistent with the defense theory of the case, as opposed to whatever it is, self-defense. You want to maybe get into a voluntary manslaughter situation, but really, I think the state's sort of focus on the planning was why they pushed the first degree murder narrative, as well as obviously felony murder that was charged as well.
Well, you guys, the jury foreman actually had the same exact questions. He was the one holdout initially, is because he thought, if I am, not me, but, if someone is on this crazy revenge mission, are they really going to go and have sex all day long and then take photos? This was actually, he gave an interview. I think you can catch it on Hulu. So yeah, these were actually one of some of the questions that he had, and he had a hard time kind of putting two and two together. So, little fun fact, little Snapple fact.
Yeah, I mean, obviously, I think the camera was just so important.
Mm-hmm.
It was at least the argument, right? The argument was over the camera, right? The camera is what triggered, the attack and the self-defense, and of course, also the camera had all the pictures of before and after the murder.
Well, obviously, we know premeditation could be 2 seconds. It could be 2 weeks, right? I mean, what do you say? Little law school, back to law school. You say this every podcast. But, so I think that, to me at least, what kind of showed premeditation were the two gas tanks that she borrowed from her friend Daryl. The gun, all those, these are not things that you just do on your way to ex-boyfriend's house when you are just going to go hang out and have sex for 12 hours a day, right? I mean, what do you need the gas tanks for? Why are you staging a burglary of your grandparents' home, where you live, by the way? And the only thing that you take is a gun that incidentally is, the
Is this Liana over here or Nancy Grace? I'm trying to get a sense of,
Well, let me say this, Leon. I think your points are very valid. But let me say this, and I'll take it back to law school. If someone does all that though with the intent to kill someone, as it was posed out to be, and then they say, you know what, I'm not going to do that. I'm not going to kill him. We've had this sexual encounter. I'm not going to kill him. Forget it. And leaves. They haven't committed a crime, right? They haven't committed the crime of attempted murder, and the premeditation ended at the point in time. Like you can go somewhere with the intent of killing someone and decide not to do it, and the premeditation ends. You have coffee, what have you, and then maybe something happens when you're having coffee, and you decide to go ahead and shoot the person. Then that becomes a different situation. So I think that an argument could be made that premeditation could be put to bed and revived.
I'm trying to think. Is this a model penal code jurisdiction? Is this a substantial step? I'm having some law school
Yeah.
a PTSD, but it's only a good hypothetical.
That's what makes this so fascinating, right? Is because none of it really all just lines up. Or she did X, Y, Z, and then there's sort of this time that's unaccounted for. Like you said, we don't really know exactly what happened, and then these photographs surface. So what are your thoughts on all of this? Is there premeditation or
Look,
not?
it's hard, and like anytime someone's involved in a murder, right? There are some instances where there's we can understand it, or there's some legal or rational or emotional justification. So obviously, Kirk and I, we cover a lot of different murders on court TV, and oftentimes we're asked to explain why. Why would someone do this? And usually there's no legal justification, there's no moral, there's not even an emotional or rational one. So we're sort of stuck there trying to explain, to get in the mind of a murderer, or at least someone accused of murder. And they'll bring psychs and all sorts of different type of mental health professionals to come in. But to answer your question, I do not know why someone would do something like this. I'm sure Maybe Kirk has his ideas. I don't know how much you can share or not, but I certainly
Yeah.
don't know. And frankly, I've never been able to explain any of these
Right.
because it's just really
Well,
unexplainable.
I was actually telling Kirk before we started that, she didn't really have these makings of a killer, serial killer, what have you, that we talk about every episode, right? She comes from a, decent family. Everyone's tight knit, she has good grades. So for
Well,
all
she talks
intents,
about like some pretty significant abuse, at least during the penalty phase, right?
the penalty, yes, but up until she was 18 years old, when her parents caught her like growing weed, I think, or something like that, and they got into an argument, and she left the home. But up until then, there's really nothing that, we've talked about nature versus nurture, right? I mean, some of these killers really experience some sexual abuse and trauma, not really here. That's why I think it's so fascinating, at least for me, right? Like what happened here? But you're right. I guess we'll never know. But what are your thoughts, Kirk?
Well, you know, it's interesting because we see these cases, as Nima said, over and over again, that people in these toxic relationships, and I think we can say safe to say that Mr. Alexander and Miss Arias had a toxic relationship. And I should back up and say, what I'm talking about now, what I've said previous about the 12 hours and everything, that is for the sake of the case, what we argued at the case. That's not my personal belief. A lot of people, one of the things that happens to defense attorneys, and one of the reasons I received threats during the case, is the idea that they believe that the defense attorney believes in their client, or that they believe in a client's argument, or what have you. And ultimately, what it really is this is the ethical defense, the defense that they are ethically obligated to present ultimately. And that's why I talk about, Miss Arias and her statements, putting myself and my family in jeopardy because we were getting threats there. So I want to make sure that we're clear in that regard, that what we've been talking about in terms of those 12 hours or anything or justifications are really what we're talking about, what happened at trial in terms of that argument. But to get to the question, with that in mind, then it's ultimately probably an unanswerable question, because we think about this arrest in the Bahamas, and this woman's name eludes me now, right? They're very well off, and they're going to get millions, and then she hires some faux hitman to kill her husband, right? And we see the case with the fentanyl poisoning, and I believe Righteous is, I believe, her name, where she's methodically, we're not talking about, I'm going to, do this and then I'm ultimately going to shoot him or what have you. You think about the methodical plotting of getting fentanyl and putting it in his coffee or in his drink or whatever it was, and then going to the point where you go on TV and write a book talking about the book you wrote on grief, right? What gets someone there? And I think one of the things I talk about a lot on these podcasts is that, to me, female killers operate a lot on image. They want to have this pristine image. They don't want male killers, and I've talked to a lot of killers, unfortunately, and male killers are like, yeah, well, this and that, and they realize the justification doesn't last. But oftentimes, I've experienced with female killers that the justification does, and you see it time and time again. Like, what kind of issue must you have, like Miss Richards, to write a book on grief and go on TV and talk about it like you're the next Oprah after you know you've killed your husband? It's because your main goal is your image. You feel justified at a deeper level than I think most male killers do in what you have done. And you also feel justified in saying whatever the heck you want about the person you killed.
Yeah, and I don't want to make this into a man versus woman thing, but we also see it sometimes in even sort of infidelity where I think sometimes women will believe that maybe it's justified. And I don't think sometimes you hear that from a male perspective, even though it might even be more common. Obviously, murder is much more common when it comes to men. But I think there is that.
Hmm.
Again, I don't know what the psychology is, but somehow there's some sort of rationalization, and it continues where. Uh,
So, question for you guys, since you've jumped ahead a little bit, but and I'm gonna sort of glance over it and then we'll come back. But we had two hung juries on the penalty phase, right? So twice we have to kind of go through. Jury is not able to come back with a penalty. And so, do you guys think the struggle here was that she was a female defendant?
I'm going to answer this because I have no problem saying that attractive females do better in front of juries.
Okay.
You know, I'm not saying that's the reason. I think Kirk and his team did an outstanding job, but your client matters. Look, even in our civil cases, I think our female clients do better in front of a jury. And I think even insurance companies and defendants know that.
Yeah, I agree. That's actually what I think too. I mean, she's young, she's female, and I think looking at her, people are just like, okay, are we going to put her, on death row? Probably not. So I think that really was the struggle, right? Because the first time they come back, what is it? Is it 11-1? And then the second time,
I think that was the second time, right? Wasn't it 8-4, 11-1?
8-4 was, I think, the first. Either way,
Yeah.
right? I mean, you see the sort of struggle twice, and I don't know of too many cases where that's happened. You guys would probably know. So.
Yeah, and one more thing I want to hear Kirk says. I think one of the biggest sort of objections to the death penalty, setting aside all the moral issues and so forth, is that it disproportionately affects men of color. So I think that's something that, again, I don't have the statistics in front of me, but I mean it's a real consideration.
Kirk, what were your thoughts?
Yeah, the statistics show that white males who, black males who murder a Caucasian person, are the ones the most likely to get the death penalty. A person of color is more likely to get it. A Caucasian person is less likely to get it when the roles are reversed. That was the studies that I was familiar with years ago. To address the issue with women, I think there is something to that. I don't know that attractiveness really is the thing, but I do think we've talked about those a little bit off tape about those 18 days on the stand, right? And in Arizona, as Nima knows or will soon know as a recent or soon to be Arizona lawyer, that Arizona is one of the states that allows jurors to ask questions. So one of the things that made it one of the things that became quite apparent of those questions is the jury as a collective was not a fan of Miss Arias. But does that necessarily lead to the death penalty? And we have to consider other factors too. And primarily, one of them being that you do have a person who lived a law abiding life for 30 years, right? And we have people, and that just also, I think, jury selection in a capital case is huge. It is the most important part because, as Nima correctly stated earlier, they are more likely to convict and less likely to sentence to death when the jury selection is done properly. And I think ultimately that's what happened in this case, that we selected the proper jury and it led to that life verdict, and not just once but twice. So, there's a lot of factors that go into that, obviously. But, someone without a criminal history, I think that is a big deal as well for jurors, because if they think you're a lifelong criminal, you're going to get out, you're going to do it again, or what have you. But I think it's different depending on the circumstances of the case. We even seen life verdicts in cases I just cannot understand how they got life verdicts. But ultimately, it was jury selection.
Yeah, I mean, jury selection, I think, is everything in every case. But and all those folks that are watching that maybe don't have legal training, but just so everyone knows, in a death penalty case, during the voir dire, during the jury selection process, the jurors are asked about their thoughts on the death penalty. And if the prosecution meets its burden, can they impose the death penalty? So jurors that answer yes to that obviously tend to skew more conservative. And if jurors that basically say, well, I can't follow the law, I refuse to do it, they might be excluded on that basis. So you tend to get more conservative jurors.
So before Noah kills me, because I know we have to wrap up, although I could talk about this all day. Final thoughts on the verdict. Was there any surprise when we came back with a guilty verdict? And I also want to talk to you, Kirk, a little bit about the T-shirt and the statement about raising funds for domestic abuse victims. And so to me, it was shocking because you sort of have this like your last chance, right? You're addressing the family, you're addressing the court before sentencing to show any kind of remorse. And instead we get her showing up with a T-shirt. Did you see that part where she brings up this T-shirt, it says victim, and she's talking about domestic abuse and whatnot. And so I thought it was kind of like a read the room type situation, not the most appropriate place. Were you guys aware that she was going to do that? What were your thoughts when you heard her speech? And then I want to hear your thoughts, obviously.
Yeah, and one other thing, I just want to make sure I think we got to talk about the appeal too, because there's some issues on appeal with the prosecutor's conduct. I really want to get Kirk's thoughts. Noah's behind the camera. Don't hate us. We can always edit it down if necessary.
Yes.
But I think, look, I mean, this is such an important case.
Yeah.
You have two penalty phases. You have jurors who, some of which were excused for various reasons. I really want to kind of shift a little bit towards, I mean, obviously, once you wrap up liability, talk about the penalty phase and talk about the appeal, which was very important as well.
Yeah. Kirk.
I'm sorry, I didn't hear a question, Nima, if there was a
Oh,
question.
so yeah, so I guess the step one, let's talk about the verdict, the guilty verdict, whether that's surprising. Obviously, we want to talk about the penalty phase and the two hung juries and mistrials, and of course the appeal. I think
Yeah.
we got to
Yeah.
cover all that.
Yeah. So let's start with, were you surprised? I wasn't at all, but were you guys surprised with a guilty verdict?
No, not at all. I mean, look, the facts were what they were. As I said earlier, the jury, the questions certainly were insightful to the disposition that the jury had towards Miss Arias. So, look, as I said earlier, whether it's Miss Arias's case or not, a death penalty attorney goes in with the expectation that their client at the end of the guilt phase is going to be found guilty of first degree murder.
I think that's right. And obviously, her testimony, the cross examination was vigorous to say the least. The experts came in, and I thought they did a good job with the evidence that they had. But like, it's a really tough battle when the prosecution is just showing picture after picture of just this gruesome crime scene and then being shot after the fact. Just a very tough case, I think. I mean, you're certainly not going to get a not guilty, right? The question is, can you possibly hang during the guilt phase? And I think it's a major uphill battle in a case like this.
Right. Okay, well, go ahead. Take it away. Talk about your appeals. That's your favorite part.
Well, no, let's talk about the death penalty.
Oh, yes.
Let's talk about the
Yeah.
death penalty, which is really, I think when, again, we're in California, capital defense, not an issue here. We've had a moratorium for years, but obviously I'm fascinated by the death penalty. We cover it so many times, Kirk and I. And the question is, you have a jury that hangs, the first jury, the prosecutor comes, they retry it, which doesn't really happen that often. And then you hang it again, barely, but you hang it again. So Kirk, what was sort of your strategy going into the penalty phase? And just kind of give me your thoughts on the prosecution's decision to retry her and try to put her to death.
Well, ultimately, the jury is taxed with considering everything they hear from opening statements till the end of the mitigation case in making their decision, right? So that's why I talked earlier about the kind of cohesion between the defense of the trial and the mitigation phase. So you try to put that together and use what you can. And so the toxic relationship, the situation she found in, what have you. And Leanna's talked about, the jurors kind of buying into that or not sure whether it was premeditation. So I think that's really where it's centered around, because really, I think people, if to impose death, to say guilty to first degree murder is one thing, but to look at someone who's sitting in a courtroom and say, you do not deserve to live, we want to kill you, is a struggle for a lot of people. And so those factors and the lack of criminal history and everything all play into it. Think about it, Nima, going back to what I said earlier, wanting to get off this case since 2009. Well, not 2009, 2011, and thinking it was going to be over a year later, what have you. And then finally, you're getting death threats, you're under the public spotlight, you've got a client doing these interviews, because remember, right after the verdict, she was doing these interviews and holding up the survivor t-shirts, as Leanna mentioned earlier. And really, on a personal, I just wanted nothing else to do with it again. And so I tell the story in my book. I was the most unhappy guy in Vegas because we were there at Christie's, my wife's end of the year school trip, a Memorial Day weekend. And there I was, just knowing knowing that the prosecutor would likely continue and try to seek death in this case. So, which meant, some of the experts wouldn't come back because of the death threats, what have you. So that was 2013, right? So the trial didn't end until 2015. So that meant 2 more years of being trapped with Miss Arias.
Yeah, I mean, that we should talk about some of the media attention too. I mean, it was so much that at least one of the experts said, "Hey,
I'm not doing this.
I'm not doing this." So then we get the appeal, right? And that's maybe the final insult. But I think something good came out of the appeal in terms of, you know, highlighting some of the prosecutorial misconduct. Well, what were your thoughts on that, Kurt?
Yeah, ultimately the verdict was upheld, and we do not have the final blast yet, Nima, because to be clear, she still has her attempt at post-conviction relief. So she can go forward to the court and claim that myself and the defense team were ineffective counsel, and that's why she got convicted. So, Leanna, you might be excited to know that we are not done with Jodi Arias yet. She will probably come back to the jail and give quite the interviews. But yeah, I mean, ultimately, by that point in time, I wasn't practicing anymore. I was done. I was so sick of the whole ordeal by April 2015, and when she was sentenced, and having my own battle with cancer that followed a few months later after the stress that I attribute to the stress of the Arias trial. Um, it wasn't as satisfying as you might think in terms of a legal situation, because really I was just done with it, and the practice of law ultimately, because I certainly at that point in time wasn't happy in my life doing it. I don't know how many happy lawyers especially doing criminal law, but not a lot. So I decided that if I was going to go into the chemo chair and battle cancer, that I wasn't going to live my remaining years the way I had my prior. So by the time years later, when that appellate decision came out, I had pretty much washed my hands of the whole ordeal and was really trying to outrun the Arias case. And then ultimately here now I've come to the conclusion that I can't run fast enough. It'll be with me for the rest of my life. As a matter of fact, I did a TV special called In Defense Of, which was with four different criminal defense attorneys that had done high profile cases. And I got to meet John Henry Brown, who was the original lawyer for Ted Bundy. And he talked to me about how that case had been with him his entire life. And I realized that Miss Arias will be with me my entire life as well. I was saying in my one man show, if I could cure cancer, world hunger, and a few other diseases, it wouldn't be Kirk Nurmi did it. It would be Jodi Arias, his former lawyer, did it. And that's just the life I have to live, as it were. That's my fate.
Well, I know we're out of time, but obviously, I want everyone to follow Kirk on social media. He has had an amazing journey. Setting aside Miss Arias, you got to get his book. But like he said, he's a cancer survivor. He's lost a ton of weight. He's on this health journey. You can catch him and I every Thursday night on Court TV primetime. But Kirk, just let everyone know where they can find you on social media.
Yeah, just Nurmi Unchained on Twitter and Instagram. That's probably the best place to follow me. And I got a Nurmi's True Crime Clubhouse on Facebook, where I discuss true crime and post articles and things of that nature. So that's what I'm up to now. As you mentioned, doing a lot of different things. I even got to model. You would think Nima would be the model, Leanna, but here I am.
Love that.
Well, I love being on with Kirk so much. Check out his book, Trapped with Miss Arias. Liana, was it everything that you expected it to be?
I just wish Noah would stop bugging us with the camera so I can just do this for a few more hours. But jokes aside, thank you so much for joining. I think this was just really fascinating to pick your brain a little bit. I appreciate it. I know Nima appreciates it. And thank you to everyone who tuned in. I hope this was everything that you hoped for.
Thank you, Kirk. Great seeing you, and I'll see you on Court TV very soon.
We will, Leanna. I hope we got to enough of your pages. Maybe you'll have me back and get the other.
I'm about to follow you on Instagram. You don't even know. Just kidding. Thank you, everyone. We'll see you next time.